Have you ever stopped to think about how a country as huge and diverse as India actually works? I mean, who gets to make the laws? Is it the national government or the individual states? It's a massive puzzle of power, and in this explainer, we're going to dive deep into the blueprint that holds it all together.
So, to really get a grip on how India is set up, you first need to know about two basic ways to run a country. You've got your unitary system, where pretty much all power comes from one central spot. And then you have a federal system, where that power is split up, divided between the center and the states. The big question, of course, is, where does India fit into all this?
All right, here's our game plan. We're going to break this down into 5 simple parts. First, we'll look at India's unique design. Then, we'll see how they draw the lines for who makes laws where. We'll explore the 3 official lists. This is the real core of the system. Then, what happens when those laws clash? And finally, we'll cover some of the parliament's pretty amazing special powers.
Okay, let's jump right in. First up, we're getting to the very heart of how India shares its power.
Now, this is what's so fascinating about India. It's not strictly one or the other. It's actually a hybrid, built to be flexible. So day to day, it runs like a federal system, with powers clearly divided. But if a national emergency hits, the whole system can transform. Power gets concentrated right at the center, and it starts acting a lot more like a unitary state. It's a really clever design.
So, how exactly are those powers divided? Well, the first big distinction is all about geography. It's about the where. Article 245 of the Constitution lays out the physical boundaries for who can make laws for which part of the country. And it's actually pretty straightforward. Step 1, the parliament in Delhi can make laws for the entire country or just one tiny part of it. Step 2, a state legislature, like the one in Maharashtra or Tamil Nadu, can only make laws that apply within its own state borders. And then there's step 3, which is crucial. Only the parliament's power can reach beyond India's borders, applying to Indian citizens and their property anywhere on the globe. And this special global reach has a name. It's called extraterritorial jurisdiction. It's a power that only the central parliament has. It basically ensures that national laws can protect and govern Indian interests no matter where they are in the world. Super important for a global player, right? Okay, so we've sorted out where the laws apply. Now let's get into the really meaty part, what they can make laws about. This is where the 7th schedule of the Constitution comes into play, and it is just a brilliant piece of organization. It sorts every topic you can think of into 3 clear lists. Think of it this way. You've got List I, the Union List. It has about 100 items, things of national importance, like defense and atomic energy. Only the Parliament can touch these. Then there's List 2, the State List. This has around 61 items that are more local, like agriculture and police. These are for the states to handle. And finally, you have List 3, the Concurrent List, with 52 items like education and forests. Concurrent means both the center and the states can make laws on them. But hang on, this system was designed a long, long time ago. So what about all the new stuff the founders could never have imagined? Things like artificial intelligence, or cryptocurrency, or genetic engineering. Who gets to make the rules for those? Well, the Constitution has a very, very clever answer. That answer is called residuary powers, and you'll find it in Article 248. It's basically a constitutional safety net. It says that for any subject that doesn't appear on the state list or the concurrent list, the power to make laws about it goes to just one single authority. And that authority is, you guessed it, the Union Parliament. This is so important. It means that as new challenges and technologies emerge, there's no confusion. The power to regulate them automatically goes to the central government, making sure India can always adapt to the future. Okay, so you have power divided up this carefully, but what happens when the lines get a little blurry? What happens when a state law seems to step on the center's turf, or the other way around? Well, the Constitution has a built-in rulebook for sorting out these kinds of conflicts. The first tool they use sounds a bit complicated, but it's not. It's called the doctrine of pith and substance. Pith just means the core, or the true essence of something. So instead of throwing out a law because it accidentally bumps into a topic from another list, the courts ask a simple question. What is this law really about at its heart? And here's a perfect real-world example. A state in Bengal passed a law about money lending, which is a state subject. But it was challenged because it also had an effect on promissory notes, which is a central subject. The court looked at it and said, look, the main point, the pith and substance of this law is money lending. The fact that it touches on promissory notes is just a side effect, so the state law was allowed to stand.
Now for the concurrent list, where both governments can make laws. The rule is even simpler. Article 254 makes it crystal clear. If a state law is repugnant to, meaning it directly conflicts with, a union law on the same subject, the union law wins. Period. The state law becomes invalid wherever it clashes. All right, for our final section, let's look at some truly exceptional situations. The moments when the normal federal balance gets tilted and the central parliament gets to make laws on subjects that are usually reserved only for the states. There are basically four big scenarios here. First, as we mentioned, during a national emergency. Second, if the Rajya Sabha, that's the Council of States, passes a special resolution saying a state-level issue has become a matter of national importance. Third, if two or more states actually ask the parliament to legislate for them. And fourth, if it's needed to implement an international treaty. Each one of these shows just how flexible the system is designed to be. So when you put it all together, you have this incredibly detailed, flexible, and powerful framework for making laws. But it was designed over 75 years ago for a brand new nation. And that leaves us with a big question to think about. For the fast-moving, modern, 21st century India we live in today, does this system still strike the right balance between a strong center and powerful states? That's the conversation that continues.